Ready? We are now going to hear the argument for State versus Miller. Mr. Taylor, you may begin.
Thank you, Chief Justice, Counsel. Honorable Justices, may it please the courts. I'll begin with a hypothetical. Let's say this case involved an adult film actress. An adult film actress takes a video of herself engaged in sexual relations with another person and posts that video onto a pornographic website like Pornhub. Now, would it be a legitimate, logical inference to make that she was sexually gratified by the posting of this video? Would that be a logical conclusion to reach? The answer is clearly no. Obviously, there could be other motivations for a person like that, including financial motivation, contractual obligation, whether...
She was the one that posted it of herself? Is that what you said?
In this case, Your Honor, in that hypothetical, she posted herself. But the whole point of that...
Different from this case, though. Let me give you a hypothetical. Let's say you and I are sitting across the table from each other and we're having a meeting, a real meeting. We're not in any relationship with each other or anything like that. We're talking, and then just out of the blue, you slide a picture across the table to me. And I look at it, porn. For lack of a better word, it's just downright porn. At that moment, I, as the victim, can't think of that as any other way than perhaps being a sexual type of a action. How is this any different than that when your client put an image out there for others to see?
The issue with the hypothetical and the question, and I think with the Court of Appeals and District Court, is because something involves pornography, nudity, sexual content, that there is an assumption based on just that fact alone that the reason for the person to show a video like that, a picture, image, what have you, is sexual gratification.
Thank you. I think there's sort of a confusion in the discussion about how many purposes there could be, right? I mean, the question is, under the statute, sexually motivated means that one of the purposes for commission of the crime was purpose of sexual gratification. So just taking your hypothetical and coming back to you with it, I feel like maybe there are some folks in the porn industry that do get sexual gratification from putting out their anatomy and such into the interweb. Couldn't that be one of their purposes in addition to their money? And therefore, likewise, wouldn't it be the case with your client that they could have been sexually gratified by putting a film of their anatomy and a sexual act out there?
And I think that goes to the ultimate problem with this case is, yes, is it possible that's one of the motivations? Sure, but that's pure speculation in terms of deciding whether it is one of the motives.
Standard of review, that's sufficiency of the evidence. And so we're going to look at it in the light most favorable to the state. You got a picture of your guy, his own video showing his own private parts erect, which I think most everyone in the room would agree he himself at that moment it's reasonable to assume he was sexually into it. And then he puts that, the moment he puts it on the porn site, he doesn't walk away from that sexual moment. I kept reading about it in the evidence. He has his phone locked and loaded and ready to go to show somebody that very video. That example I gave you of somebody sliding it across the table to me, could it be he gets his jollies off of watching you watch that thing?
But it also could be motivated by revenge, trying to embarrass another person. That is a possible motivation.
District courts, though.
And that's true, but the issue with this case is that we're taking one single piece of evidence, the fact that this video was uploaded to a pornographic site that contained nudity and sexual content, and from that one piece of evidence, even though there is just as likely a motivation regarding sexual gratification, there's also a possible motivation, which is clearly established in the record based on the testimony of Dr. Thomas, that the motivation was revenge, some sort of childish way of getting back at an ex-girlfriend.
Here's my question. All right, so we're reviewing it with sort of essentially kind of a bench trial on this issue. And so we have several sentences of finding from the district court. Are those the findings we need to review and decide whether they provide the result? Because is that the the universe we should be looking at.
I mean, in terms of what the court's findings were, that's what we're looking at, is the court's conclusions regarding sexual motivation. But again, the sexual motivation that the court concluded on was based upon other things that are not necessarily relevant under this statute.
I want to go to that point. A question of timing here. What is the time period that we're looking at for when he was gratified? Is it at the time that he posts it? Is it at some later time when he's showing it to Mr. Leak? What should we be focusing on in terms of the timing of the gratification?
Under this statute, the only thing we should be looking at is the actual posting and the disseminating of this video. The fact,
Subsequent actions, like the showing it to the other person, couldn't that be evidence about his overall motives too, though?
I'm not here to argue that the court cannot consider other acts that are not in themselves illegal. Obviously, when it comes to intent, the court gets to consider all relevant facts.
You're talking about whether or not we're not going to hardly ever have evidence of somebody masturbating while they download something. That's just not going to happen. It's going to have to be based on circumstantial evidence, isn't it?
That, but the issue here is what we're pulling off of is obviously someone videotaping themselves having sex. There's gratification in that. I think that can be presumed. But that doesn't necessarily mean the motivation of posting something on the internet is sexually motivated. We have
Porn site, and I want to get to that with you too. This isn't really porn, is it? Don't you have to have two consenting people to make porn? She didn't know about this. Wouldn't that be correct?
we have on that point, and excuse my David Letterman impersonation here, but that was hearsay evidence that was admitted, and defense counsel in that case probably should have more timely objected and objected a little too late. But the only evidence in the record about whether she was aware of this video being taken is from hearsay testimony from the officer.
There's some finding, I think, from the district court that your client viewed the video from the website itself versus from his camera. Is that correct? I mean, I'm not sure I found that in the transcript, but.
The ruling was referencing that likely that Mr. Miller was one of the views that was part of the accomplishments or views of the video. And again, I don't think that is really the relevant question here, because obviously someone that possesses the video probably had a chance to view it, but that is not.
And that, but is that correct? I mean, the district court says something like 1,300 people viewed it, and I think you were one of them, and I don't know where that came from.
It's part of the ruling. I don't necessarily agree that that was actually a factual issue that was established, but.
He showed Mr. Leak, I believe is his name, the video on his phone. Isn't that factual? And wasn't that from the porn site? So wouldn't that necessarily require him to click in at least one of those however many clicks are his own? And that was after the fact. Access to the porn site.
That's not necessarily the issue that I think is relevant in terms of.
It was downloaded for the purpose of sexual gratification. I don't know of too many people who regularly watch porn that aren't doing it for sexual gratification.
There is a different motivation for posting a video versus going to a website to view the video. So, correct. And so if we're going, and that's why I open up with this hypothetical, we're talking about someone that has other motivations to posting a video, not for sexual gratification, an adult film actress.
It has to be for his sexual gratification, not someone else's. But the question is, isn't there some evidence in the record from which the district court could infer that he did it in part for his sexual gratification?
With that, the testimony that we have from Dr. Thomas says the motivation was for revenge. The actual posting of the video and having it displayed on a website, that is the ultimate question. It doesn't matter if, in terms of how he viewed it or his motivations for taking the video, it's the publishing of that video. That's the ultimate question here, is whether that was for sexual gratification.
About revenge, I don't think anybody doubts for a moment what he did was very vengeful, incredibly vengeful. But it appears, I don't know if you've ever heard of something called image-based sexual assault, and that's something that this is being called these days. And what what is your take on that? Isn't that perceived, or isn't that an argument that just because we're supposed to look at the perpetrator's state of mind in a sense, doesn't mean there isn't an effect on the other person, and that can be sexual gratification as well?
Well, in terms of the question I think you're posing is now a question of whether this is appropriate to punish someone for an activity like this. And really what we're talking about is whether someone should be labeled a sex offender and subject to additional scrutiny from the state in terms of how they live their lives. And so I don't think really what we should be just focusing on is whether a person in their activities is just purely a criminal, petulant, immature act of posting a video online in purposes of getting revenge back on an ex. And again, not arguing that's the right thing to do, but whether that's sexually motivated that requires to be placed on the sex offender registry.
Punished for the offense of injuring this woman by posting the video, right? I mean, he pleaded guilty to the crime. We're dealing with a separate issue about sex offender registration, right?
I mean, this issue of whether it's sexually motivated has nothing to do whether this is a right act, wrong act, whether he was justified.
Chosen to enhance penalties such as harassment if it has that undertone. And that's what we're dealing with. I mean, of course, he's been penalized for the harassment, but our legislature has made a conscientious decision to enhance it, and that's why we're here today. If that is considered an image-based sexual assault, because the example I gave you at the very beginning, where you slide a picture across the table to me, I would feel assaulted at that moment if that was a disgusting porn picture. I didn't ask for it. I have nothing to do with it. I would be incredibly insulted, perhaps maybe even considered an assault. And it's sexually based. How is this any different? And that person who was sliding it across the table saw my reaction, perhaps maybe liked that reaction. Isn't that something we can consider?
If your reaction and the reason they're taking enjoyment from that is because they just like offending people and they're just kind of a jerk, does that justify putting someone on the sex offender registry?
Louisville sluggard at both headlights, like Carrie Underwood says, that's when you don't put them on the sex offender registry. That's true revenge. This is more than that.
Legislature's intentions here, this is not a sexual crime per se that requires a registry per se. That's why there is a separate issue in terms of deciding beyond a reasonable doubt whether this crime is sexually motivated for those purposes. The legislature gave that discretion and decided that because this crime could encompass so much more motivations besides sexual gratification, that's why they allow for this to be separate. Many other charges under the sexual assault statutes under 709 are per se requirements to be on the sex offender registry. Harassment, this section of harassment is not. And that's why we have to really identify whether this crime was sexually motivated and whether there's proof beyond a reasonable doubt. Now here, we're talking about inferences, and we're not, the main issue is that the only piece of evidence that really establishes anything is that this video was uploaded to a pornographic site. I mean, we can talk about the fact that the video was recorded and uploaded.
What do we make of him showing it to Mr. Leak? I think that's the other kind of big question mark here. And the fact that he shows it to someone from that website, I don't know.
In that example, and the Court of Appeals talked about not showing it to family members and how you really truly enact revenge. I think all you can take from the Mr. Leak testimony is that he could possibly just be doing it just to embarrass his ex-girlfriend some more. I mean,
The Court of Appeals had on page 10 of their opinion, his claim of revenge motivation is not supported by the evidence due to his failure to inform the victim, her friends, or her family. That's a lame type of revenge. If you don't even do anything, you don't take any steps to make sure the person knows you got them. Instead, they showed it to a video at a guy in the bar, based on my review, wasn't her boyfriend yet, but later became her boyfriend, and that's how she learned. Isn't that true?
true, but I don't think there is one way to enact revenge. I think that just saying that there's only one correct way, that you have to show family members, you have to show people that know, that's also just speculating a lot into evidence. We don't know if Mr. Miller knew her family or friends, had the ability to contact, did he change her number? We have to speculate about his access of sharing that information.
State's burden to prove beyond a reasonable doubt that he had a sexual motivation when he posted the video to Pornhub.
that was on, the burden's on the state, and so that's why we have to look at this one piece of evidence and determine if, with all these other motivations that are possible, and especially when we have in the record an expert talking about revenge being the motivation, if we have one piece of evidence, just like the Truesdale case, and if you have two inferences that you can make from that one piece of evidence, is that speculation?
Is it not a reasonable inference for the fact finder, the judge, to make that sexual gratification was one of his motives?
Again, what we're focused on is that this video was uploaded, and there's nothing else to say if his, well, we have expert testimony saying his motive is revenge, but to say that it was sexually motivated is just speculation. That's what it is.
Chief, may I? You're not suggesting that the district court was under any obligation to believe the hired expert?
No, the only reason I bring that up is that there is part of the record, another justifiable or another reasonable explanation as to the motivation of Mr. Miller. I'm not saying that the court was obligated to take Dr. Thomas's testimony at face value and accept it.
A case, the Isaac case, I think it was, about the person who gets caught, sort of the peeping Tom. There was some discussion of that in the brief, and sort of he was sort of like a he was a peeping Tom, but also kind of like a flasher, right? He sort of won, and the question was whether or not he wanted his anatomy to be seen or not. And I think the question in my mind is, isn't it enough if somebody is sort of purposefully showing their anatomy, going to the chief's point, sort of purposefully showing their anatomy to the world? Isn't that something that could suggest sexual motivation?
The Isaac case just references the fact that in that particular situation, you have someone that's engaged in a sex act, but because of the facts and circumstances around it, there wasn't enough to show that that sex act was for the purposes of showing to someone else.
What? Give me an idea of what would ever hit your level, because you're saying there was no evidence. I think there was. But if not this case, give me an example of harassment with a sexual motivation where you've got a porn site involved.
Christensen, I'm just a lowly defense attorney. I'm not a highfalutin prosecuting attorney for the state of Iowa, and it's not my job to necessarily prove my client's guilt here, but there are facts and circumstances that would make more sense in terms of showing that someone is motivated by.
Give me an example. We engage in hypotheticals here. I'm not asking you to do his job. This is a separate case. How do you do that in a kind of a crime like this where, like I said, you don't watch people masturbate to stuff. People do these things in private. So how, without circumstantial evidence, could anybody ever satisfy this?
Circumstantial evidence in situations, it just doesn't present itself here. Is we talk about the timing of the video. If the video is being taken of someone and then it's posted up on a pornography site the next day, that could be a reasonable conclusion that the whole purpose of that video being taken was to be placed on the internet. But again, in this particular case, we're talking about an extended time period of when they were in a relationship, the video was taken, and then after the relationship, after it ended in an ugly way, that's when the video is uploaded to the internet. And so it could be a timing where circumstantial evidence shows that because of the timing of the video, that would demonstrate that there was sexual motivation. It just does not exist in this case.
Okay, your time's, well, you'll get to come back. Mr. Siefert. And would you start right off with telling me how long was this relationship? Wasn't it only like 2 months?
Chief Justice, Your Honors, Counsel, I believe it was only a couple months. I have that the video was taken in May or June of 2019 during those couple months span of their relationship, and then it was posted, I believe, in or around September of 2019. So the relationship was relatively short, and then there was some gap of a month or two, I believe, before it was posted, is correct. Kind of more broadly speaking, to back up, though, from the state's position and point of view, this is not a particularly difficult case. The uncontroverted facts here before the district court were that Mr. Miller posted on Pornhub a sexually explicit video of himself and his ex-girlfriend. He did that without her knowledge. And then it was posted for a duration of, I believe, 10 or 11 months before she found out, during which time we have evidence that he directly showed at least one person.
Haven't gotten me there, at least personally. Get me to the evidence that this was done for his, at least in part, for his sexual gratification.
Sure, Your Honor. And direct evidence, I don't think we have it. We don't have, the circumstantial evidence, I think, can be fairly inferred from those facts. And I think that basically goes to the Chief's question, if not this, what?
Somebody does a revenge porn, which I presume they do it by posting it on a pornographic website, that's automatically for their own sexual gratification. Is that the state's position?
Saying that precisely, and I think that's one of the differences between the state's view and counsel's view, is that I'm not saying it's a per se, meshing the two components of that statutory process into one. I'm saying that is, with those facts, substantial evidence upon which the fact finder can infer that it was sexually motivated.
Statute. So 229A2 says sexually motivated means that one of the purposes for commission of the crime is the purpose of sexual gratification of the perpetrator of the crime. What is the crime in this case?
In this case is the dissemination, posting of the video without the knowledge of the ex-girlfriend.
The law doesn't make that a crime. This statute says the crime is done with the intent to intimidate, annoy, or alarm another person. That's the criminal act. Posting the video without her knowledge and consent is not the crime under this statute. Would you agree with that?
I guess at the risk of inviting more specific questions, I don't know that I would agree with that, Your Honor.
The crime to which he pleaded guilty. Let's make it easier.
When you do one of the following with the intent to annoy, alarm, and then the subsection at issue is the posting, dissemination, publication, or causing to be posting, disseminated, publishing.
Says that the purpose of the crime, not the actus reus, but the criminal act itself, the elements that make it criminal, have to be done with sexual motivation. So it seems to me that if that's correct, then we have to be a little bit more granular instead of just saying, well, he posted it, therefore it's sexually motivated. The criminal offense of trying to annoy, alarm, intimidate, or harass her is the relevant crime, unless you're telling me that there's some other crime at issue.
No, Your Honor, and I guess I'm not quite catching your drift. That is out of the state's argument, that the act of posting it, which I don't think the state has ever argued, even at the district court level, was not in part for revenge, was also motivated in part by Mr. Miller's sexual gratification in doing it.
Read this statute, it says that the crime has to be sexually motivated. And in this case, the crime is the intent to annoy her, the intent to intimidate her, the intent to harass her. And if we read the statute correctly, the sexual motivation has to come from committing that crime. That he receives sexual gratification from intimidating, harassing, or annoying her. Otherwise, you're saying he's sexually motivated to do an act that's not criminal in and of itself.
So I think I'm following now, Your Honor, and I guess from my point of view, I don't think that is divorced from any of the findings in this case. I think if you look at it broadly, I think the district court had evidence, albeit hearsay evidence, but unobjected to hearsay. The girlfriend was unaware of the video until she was later told by her then fiance that it had been posted. I think the district court therefore could have found that Mr. Miller was not credible, saying that it had been consensual. I think then what comes into play is this kind of, I guess for lack of a better term, sexual power dynamics issue, where he enjoyed taking a video that she didn't consent to. He was in a powerful position. Later, he is kind of emasculated when she cheats on him, I believe was the testimony in front of the court. and now I can make this decision to post it. The act of doing it, while I think also vengeful, is now back in a position where I have put it on a pornographic website where many individuals, hundreds if not thousands, we know it was in the thousands, are likely to see it. The only purpose they're going to be finding it is going on a pornographic site, searching for it, likely masturbating to it.
Do you agree then that the timing that we're looking at is at the time of the posting?
I don't agree with.
Okay, so
A Court of Appeals cited, I believe it was from In re Blaze, but I could be mistaking which case it was from, that the timing is more broad, that it's forward-looking. It's not when the button is clicked.
Of a nuanced, sophisticated argument now. Here's what the district court said. Choosing a pornography website demonstrates defendant's continued interest in the sexually obscene content of the video. I mean, that seems to me kind of a finesse. That's not really saying he's doing it for sexual gratification. The word sex is there, but that finding doesn't seem sufficient, does it? I mean, I agree that's not the only thing the court says.
Disagree. I think I'm perhaps just saying it differently. To me, the implication of both the district court and the Court of Appeals opinions is that it is a very important fact, which I think carries a lot of weight here, where he chose to post it. He could have put the video on a disc and put it in the mailbox of her family. He could have done any number of things. Instead, he chose a place where he knows people will be watching him.
be watching. Is that for his gratification?
And that's where we don't have direct evidence that he enjoys being watched, but I think that's a reasonable inference.
The video he showed Mr. Leak in a bar, wherever he was on his own phone and from the porn site.
And I think it is certainly a fair inference. What we know is that he showed Mr. Leak, that Mr. Leak was then later able to tell his fiancee, and she was able to find it. Presumably, he would have had to know what site it was on and what the title was to be able to go search for it and find it.
Leak's testimony is very brief. The state puts him on, and he says the whole thing was pitiful. He doesn't talk about anything. I mean, the state put him on, could have asked him questions. He doesn't talk about anything about how the defendant was acting or behaving while showing Mr. Leak this video. I mean, all of his testimony is consistent with a revenge. Where is it in there? Where in Mr. Leak's testimony do you get the sexual gratification part from?
Your Honor, just to be clear, I'm not saying I'm pulling it out of Mr. Leak's testimony specifically. What I'm saying is I think the choice of posting on Pornhub is just inherently different and qualitatively different than many other choices that he could have made. And I think that allows the fact finder to then infer that if he is posting a video that he himself is in on a pornographic website, knowing what is going to happen, that many people will be viewing and masturbating to that video, he is inherently in that choice, at least to some degree, accepting and deciding he is okay with and likes that outcome, that he enjoys that other people will see him in the video.
He may like it, but is it sexual gratification for him? And here's kind of my concern with this case, is you have an expert come on for the defense. Well, let me start with this. It's the state's burden, and it's not a preponderance, right? We're dealing with the highest evidentiary burden. You have an expert witness come on for the defense who says, I've interviewed this defendant, I've done a clinical examination, I've read the relevant literature, this is clearly revenge motivated. And the only evidence the state has is the act, really. I mean, it's posted to Pornhub, and you say from that, all of these inferences can flow. And maybe they would be supported by the literature. And maybe if there was another expert who came on and said inherently this kind of conduct is at least in part sexually motivated. But none of that was offered here. And so that's my concern, is that you're asking us to draw maybe a lot of inferences that might be supported by academic study that we could go out and independently research, but the state didn't put on that evidence here when it had the highest burden. That's my very practical concern with this case, is that the state is treating this like a per se violation.
Honor, I will,
Motivated, not violation.
so I will agree on the front end is the state's burden beyond a reasonable doubt. Kind of from there, I will gently disagree. I think the distinction here, the state is not arguing that it's per se, but the evidence here was substantial and allowed the fact finder to make the determination it did. I think, you know, there's many hypotheticals that would fall within this statute.
Stop you for a second right there. Okay, so you say it would allow the fact finder to find. Here, the district court did rely on some facts from, like, that he planned to record the video. So that's back in May or June. Not when he posted it in September, which is when he would have been harassing her. If we as a court say, okay, we really need to focus at the time that he was harassing her by posting, what evidence, specific evidence focused on that time frame supports beyond a reasonable doubt that it was sexually motivated?
I think the same evidence here, the facts that support the commission of the crime itself, as I said, the posting without her knowledge of the video, where he posted it, that he showed it to another individual, I think those all combine. And again, I think the difficulty here, and part of it is, again, as the chief said, if not this, what? You can imagine many other criminal acts that would fall under the statute that are just fundamentally and qualitatively different. Say Mr. Miller was a senior in high school, he'd just been expelled, and he was very upset at the principal. So he hacks his phone, finds a nude photo, blows it up into a giant poster, and puts it outside the school. He has committed this crime, but it's a fundamentally different set of facts than what we're dealing with here, right? And I think that's...
I mean, that case, it seems like where the underlying act involves some sort of sexual conduct, you might need a little bit more maybe to draw an inference. So Isaac, right, you have a guy, I think, who's masturbating while looking in a window or something. And then the cops show up and he turns around and he is exposing himself. And the issue is whether or not the exposure to the police is sexually motivated. And our court says no. I mean, what he was doing before was sexually motivated, but, you know, that's not. And it seems like we need to be more granular in the way Isaac was. And the district court here kind of, I think, commits the Isaac mistake, which is says, well, at the time they were having intercourse, he was being sexually gratified. Therefore, his subsequent use of the video was also sexual, motivated by sexual gratification. It seems like in Isaac, we said you shouldn't allow that kind of inference.
disagree and say that when I read Isaac, that is essentially that the unintentional exposure is then different from the original, that he's surprised by the police, he doesn't even realize that the officer's there, he had no intent kind of in that direction. I think here, and just to be clear, even as early as when the court was issuing its order on the bifurcation issue, it was explicitly recognizing that this was a separate issue that it had to decide where it could be sexually motivated or revenge motivated. I don't think there's a misunderstanding by the district court that it's all conflated into one. And I think the last thing I would say before I quickly, if I can have one moment, address a little bit briefly the expert issue that you'd raised and then got sidetracked earlier. It's not revenge or sexual motivation here. It can be both. And I think the issue with the expert, if you go back and look at her testimony, and I don't want to go through all of it and get minutes beyond here, but she was treating it the way I read it, almost as if she was testifying in a 229A civil commitment. She was trying to establish first if he had a paraphilic disorder, which is not required here. She was trying to look forward as to whether he would offend again. And then when pressed on cross, she kind of admitted eventually, yes, a component could be the sexual motivation, that it wasn't just choosing one or the other. And so I I do think that the district court and the Court of Appeals opinions were getting granular enough. I don't think just because the defendant finds an expert to testify to one that the expert is kind of usurping the role of the district court. It's just a witness, although a more learned witness kind of than a typical, and it can be disregarded and found not credible. So unless there's further questions, the state would request that you uphold the district court's finding of sexual motivation and affirm the sentences.
Mr. Taylor?
Thank you, Chief Justice. I keep hearing the state's argument. I read it in the Court of Appeals and district court decisions, and I'm still not really understanding really what the actual circumstantial evidence that leads to this conclusion. Now, when we keep talking about this pornographic website, and that's really what the state is leaning on, is the fact that this is a pornographic website, the simple fact is that that's where videos showing explicit material can be published. You can't publish it on a YouTube because they have, or YouTube, Facebook, or anything similar because they have content restrictions. So you cannot post it on those websites. So I don't really think that actually leads to any sort of conclusion that this is sexually motivated. It could be just very well.
It's because it's sexual. So, of course, it's not on those websites, like Apple or anything else.
By its very nature, is always going to deal with sexual material. That's what this harassment statute involves. And so to say that just because this crime involves some sort of sexual component, that it must require a registry requirement, that just should not follow because the legislature.
That should not be an automatic. I agree. Just because I think you are, I think it's interesting that there was an expert to talk about whether or not there's a sexual component when maybe this is just something that's really simple. That very first example I gave you, he had it in his hand and showed it to someone. Couldn't that be perceived as, I'm showing you something very sexual in nature, it's going to catch you off guard, it involves my anatomy as well. Can't that be a form of sexual motivation? Right there. I don't even care if it's guy to guy, guy to girl. Isn't that evidence? That's in the record.
But we go back to the point of, if this is one piece of evidence that we're discussing and you have an inference that it could be something involving revenge motivation or just trying to be obscene and get a laugh versus sexual gratification, if you have two conclusions you can reach from that one piece of evidence, then as the court in Truesdale held, and as the court looked back in the State v. Ernst decision, if we're talking about one piece of evidence, that makes it speculation, and that requires a reversal of the district court's decision. So that's the main issue here, is that this one piece of evidence that we're talking about is the posting of this video.
No, I keep bringing up the other piece of evidence. Showing a guy at a bar, that's another piece of evidence. That's not just the fact that he posted it. It did not end then. He did not walk away. If he'd have walked away, we wouldn't be here because she didn't even know it was out there. He didn't walk away.
But we're talking, so we're just, when he showed Mr. Leak the video, he's showing a video from Pornhub, which again, as the state tries to argue that the appropriate way to enact revenge on an ex-girlfriend, not appropriate, but the only way you can do it is to make sure that you show their friends and family, and that's, he's showing other people to embarrass this woman. That is an absolute logical inference that you can make from that piece of evidence. It's the same as just posting it on a pornographic website. Those two you can both lead to the same conclusion of it could be revenge motivated or it could be sexual gratification. And that's the issue. When we talk about that, if you have these two logical conclusions, then that's speculation in terms of what the actual motivation is. And so, in going to, just want to touch on something about the Blasey case in terms of the time frame of what we're talking about. Something the Court of Appeals decision referenced, and I don't think is exactly what Dr. Thomas was testifying to, but in Blasey says gratification doesn't mean it has to be like that instant in terms of the actual act. It can be something that's more forward-looking. But it's not talking, that holding is not saying that we can consider all this other activity that is not involved the posting of this video with intent to annoy or alarm. You still have to look at that. It just doesn't mean that right when he hit the button to post this video on Pornhub, that's when he received, he was aroused or masturbated or anything like that. That's what Blasey holds. You can look more forward, but it doesn't all that is still consistent with the issues in terms of what we're looking at is the recording of the video is not necessarily relevant to the posting of the video. Possessing the video, again, does not necessarily lead any credence that the video was posted because of purposes of sexual gratification. And again, I think ultimately, just to point out that this case, I mean, resembles in terms of this State v. Fentner, where the court held, in Justice Christensen's opinion, that you cannot make these jumps to conclusions just based upon the evidence. There we have a case where the defendant or defense counsel admits to use of marijuana, but also discusses the fact that this individual also or worked at a daycare, and that was a jumping conclusion. And I see that my time is up. Request that, on behalf of Mr. Miller, that the district court and the Court of Appeals decision be reversed. Thank you.
The case of State versus Miller is hereby submitted, and court is adjourned for the day.